Hi, I'm Carly Duckett and I'm a solicitor in the Commercial Disputes and Regulation team at Shepherd and Wedderburn. In this video, we're going to talk about what happens when parties don't perform under contracts. When contracts are put together, everyone is driving towards a shared objective. Difficult issues can be parked and forgotten about, or a halfway house is found as both sides try to conclude the deal. Sometimes things then go wrong later on, and if they do, the first thing we recommend is talking to the other party. It is far better to work out a solution than to immediately take a legalistic approach. But if a solution can't be found, then you might need to think about your rights under the contract. The starting point for any legal remedy will be the contract itself. So it's important to think about whether there are any specific clauses that deal with this particular breach. And if not, you need to ask two questions. Firstly, is the breach material or immaterial? And secondly, what remedies are available? For example, can you claim damages, or if the breach is serious enough, can you get out of the contract without penalty? Material breaches go to the root of a contract and are serious enough to constitute a substantial failure under the contract. In English law, these terms are called conditions. If there has been a material breach, the innocent party may be able to terminate the contract or withhold performance of their obligations until the other side rectifies the breach. On the other hand, immaterial breaches, which are called warranties in English law, usually stem from failures to comply with minor or more technical provisions of a contract. Immaterial breaches won't allow a party to exercise self-help remedies like termination or withholding performance. Doing so would put the aggrieved party in breach of contract themselves. Instead, you can seek specific implement, which means making someone do something, or you can seek damages. In some circumstances, it can be difficult to judge whether a breach is material. To help make things clearer, you can agree what breaches will be material from the outset, by including a clause within the contract to this effect. For example, you could agree that any non-performance of a particular term or a failure to perform on time will be material breach under that contract. This can be a helpful clause to include, especially if there's a particular term of the contract that is important to the parties, but might not otherwise be considered material. With that said, each case and each contract is different, which is why it's best to talk it through with a specialist, or even better, talk it through with the other party. If you'd like to find out more about the contract services we offer at Shepherd and Wedderburn, please get in touch with a member of the Commercial Disputes and Regulation team.